She was duped into not knowing what was happening with the money and constantly churning, oh, he's doing an excellent job, please pay him all this extra money that he is completely not entitled to through the fee agreement that was signed. So all of this stealing takes place, $400,000 plus of money that Errico did not earn, was not entitled to, was never accounted for in the guardianship. These lawsuits were never floated to the guardianship court. Everybody knows if you have a person who's under guardianship and there's lawsuits being settled on their behalf, you have to float that to the guardianship commissioner so it can be approved. There needs to be court approval here. None of that occurred.
I apologize, I'm running a little bit late this morning. Injured my hand this last weekend, and today was the first day I was supposed to change the bandages myself. And it's a bigger challenge than I had anticipated. So I do apologize for running late this morning.
No problem.
I think every other district court is running late too, Your Honor. No need to apologize.
Yeah, I don't like to be like too late. Anyway, we're here. Let's go ahead and call the case, State of Nevada versus William Errico, C307611. Counsel, go ahead and make your appearances for the record.
J.P. Raman, bar number 10193 for the state of Nevada.
Good morning, Your Honor. William Terry appearing with Mr. Errico, who is present, 1028, and with the court's permission, this is Ms. Wilder. We would like to have her be allowed to sit at counsel's table. She is an attorney.
Well, I understand that you want it, but you know, we sort of dealt with this the other day. Is she part of your team? If she's not here representing him, then I'm not going to allow her to sit at counsel table.
She's controlling the exhibits.
All right. If you're saying she's here to assist you in administrative tasks such as that, I'll allow that to happen.
Yeah, the technology, if I could use that.
All right. That's okay. For that, on that basis, I don't have a problem with her sitting at the table.
Thank you.
All right. Well, we're on for the evidentiary hearing. Have you guys talked as to how you want to proceed today?
Yes, we have, Your Honor. I think we've already argued the motions. We'll present witnesses. I believe Mr. Terry has none. I have two. First will be on Blue Jeans. Second will be live and in person. I suppose since they're my witnesses, I'll begin questioning. Mr. Terry will cross-examine, and then we'll argue about what the evidence yielded at the end.
That sounds like a plan. Does that sound good to you, Mr. Terry?
It does, Judge. The only question, and I concur with counsel, we've already argued the motion. I know the court's reviewed everything, reviewed the documents. So we're just going to need some assistance from the court as to whether you want us to go back into that.
We'll see. Let's wait and see when we get there. I mean, the evidence may raise some questions or some issues that would justify additional argumentation on past points. But let's see where we are at the end of the picture here.
That's fine, Judge.
All right. In that case, go ahead and call your first witness.
Okay, he's on Blue Jeans. His name is Kevin Mwangi.
All right. Is he there? He's there. Is he on mute?
Take yourself off mute.
Yes, I am, Your Honor. Sorry about that.
No problem.
guys either agree or I order.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure.
There must be an evaluation of this difference.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
They can take all the time.
I find you in contempt. I am going to incarcerate you.
Pursuant to that Supreme Court rule, your death penalty qualified.
You knew the number of times at any hearing I have to ask people to take themselves off mute. This is part of the new system we're on. So anyway, I am going to need you to rise if you're able and to raise your right hand and be sworn in by our clerk.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Have a seat and state your first name and last name and spell them for the record.
First name is Kevin, last name Mwangi, M-W-A-N-G-I.
All right. Go ahead, and whenever you're ready, counsel.
Mr. Mwangi, hi, good morning. My name is J.P. Raman from the District Attorney's Office. How are you?
I'm doing well, Mr. J. Thank you.
And are you currently employed?
Yes, I am.
Who do you work for?
I work for Nevada State Bank, the custodian of record.
You said Nevada State Bank?
Yes, as a division of Zions Bank Corporation.
Okay.
Judge, is it me or am I having a little trouble hearing him?
I can hear him. Can we turn up the sound at all? What kind of mic are you using, sir?
I'm using a Plantronics microphone. It's a headset.
Improved. Did you do that or did he?
I don't know which.
All right. Whoever did it, between our recorder and you, the sound has improved substantially. I thank you so much.
Okay. Mr. Mwangi, how long have you worked for, is it Zion's Bank Corp?
Correct. 20 years.
20 years. And Zion's Bank Corp is the parent company of Nevada State Bank?
Correct, yes, sir.
Back in 2008, 2009, when the financial crisis happened, did Zion's Bank Corp, Nevada State Bank, take under receivership a number of Nevada banks?
Yes, they did.
And did you operate as a custodian of records for those banks as well?
At the time in 2008, no, I started around 2010.
Okay. But the entire time that you've worked for Zion's Bank, you've worked for Nevada State Bank as well?
Yes.
Okay. And I'm going to refer to State's Exhibit 1. It's a disc. It's a proposed disc at this point. For the purpose of this hearing, I've spoken with Mr. Terry. Neither of us are going to object to our exhibits for the purpose of the hearing alone. It's not like these things are going in front of a jury. So obviously, if there are critiques to the evidence, it goes to the weight, not the admissibility at this point. So I believe that's agreed to.
We concur with that, Judge.
All right,
Goes to
so
weight,
just so
not
we're clear,
admissibility.
you've got a disk with documents on it.
Yes,
How are the documents distinguished on the disk?
by file names.
By file name? All right.
I'll lay a good foundation and record for each thing we're going into.
And you know what's on the disk?
I do. I've reviewed the disk.
Okay. All right. You're good with so I'll go ahead and you're good with me omitting disk Exhibit 1.
Correct. Now, we submitted hard copies to the court of our exhibits, and of course, Mr. Raman, I'd ask that those be the documents to be allowed to be considered by the court. The reason we gave it to your early judges so you had an opportunity to look at them if you wanted to do that.
Well, you have those?
Yes, I do.
All right. We'll figure out how this works.
All right, thank you.
I don't want to have the clerk's office bearing down on me either, so we'll
So
go
I
from
presume
there.
Mr. Raman's moving to admit his, and I'm moving to admit mine.
All right. So do you have yours alphabetized, or how do you have them designated?
There aren't that many, and they're grouped together, and they have exhibit numbers on them.
All right. All right.
Exhibit 1, Exhibit 2.
Have you got a listing of those?
Yeah, I do.
So they're exhibits 1 and 2?
I have his A and B.
All right.
Yeah.
Okay. Any objection to defense A and B then?
No, not for the purpose of this hearing.
Okay. All right. I'll note States Exhibit 1 and defendants A and B. All right. Go ahead with your question.
Okay, Mr. Mwangi, I'm going to try to share my screen so you can see the exhibits we're looking at. So for the record in States Exhibit 1, I'm going into a folder that says NSB records from NSB to LVMPD. NSB is an acronym that stands for Nevada State Bank. And I'm going into a folder that says disk created on 10/20/2011. And then a document in that folder that says custodian of records and cover letter. No, I'm sorry, subpoena is the document I'm going to, and then I'm going to share screen. So, Madam Recorder, can you keep the screen on my PC, but allow courtroom audio? Otherwise, he's not going to be able to see what I'm talking about.
This is the first time we're using it in this courtroom, so. He'll be able to hear you.
Will I be able to hear him?
Sure.
Okay, let me test that out.
Can you say something, Mr. Kevin?
I can hear you guys.
Okay, do you see the document on the screen? It's a PDF document. The header is Clark County Grand Jury.
Yes, sir.
Okay, this is working fine. Great. All right. Mr. Mwangi, I want to bring you back to September 28th of 2011. With regard to a subpoena, specifically this subpoena, and I'm going to zoom out a little bit so we can see more of it on the screen. Was this subpoena served on Zion's Bank, Nevada State Bank?
Yes, sir.
Okay. And what specifically was requested of your bank?
To produce records on a Mr. William K. Errico with Social Security, and we were to produce any and all signature cards, bank statements, deposit tickets, and supporting items, canceled checks front and back, loan applications, approval or denial documentation, loan ledgers and payment records, credit card applications and statements, safe deposit box applications, and box sign-out cards for the time period of June 1st, 2007 to September 27th, 2011
Okay.
on any and all accounts.
Now, did you help in the production of records on this particular occasion?
No, one of my employees, her name was Terry Wilgus, produced the records,
Okay.
gathered all the records.
And I'm backing out of this document and opening another PDF document. Same folder. It's called Custodian of Records and Cover Letter, 10/20/2011. Okay, Mr. Mwangi, do you see this document on your screen?
Yes,
What is the date on the document?
October 20th, 2011.
Okay, and this is from your bank, Nevada State Bank?
Correct, yes.
Okay, and I'm going to zoom down so we can see more of the document. Is this a letter, the first page of this document, is this a letter that is responsive to that grand jury subpoena?
Yes,
Okay, and it was authored on October 20th, 2011?
yes,
Is that around the time when the records would have been sent to the police pursuant to this grand jury subpoena?
yes,
Okay, and if we go to page 2, there's an affidavit of custodian of records. Do you see that?
yes, sir.
Is that your signature on the document?
Yes,
And this is notarized, correct?
correct.
And it's dated 20th of October 2011?
Yes,
Okay. And then there's an invoice on page 3, correct?
correct.
So somebody would have had to pay for these records?
Yes,
Now, within that same folder, there is a folder that's titled William K. Errico. And then within the William K. Errico folder, there are 3 folders, one for each account. Account 031009689, 6100466062, 6400435550. And then there's a table of contents document. I'm going to open that table of contents for you, Mr. Mwangi.
okay.
And what's the point of the table of contents document you see on your screen?
This is a summary of what records that will be provided or will be provided to accompany the records that are being put on the disk.
Okay, so that's a summary of the folders that I just listed?
Yes,
Okay. And this was done on October 18th of 2011, correct?
correct.
Okay. And let me go into one of the folders. So I'm going into the folder that was account 031009689. And in that folder, we have 2 documents, one for the account and one says SIG card. What would be SIG card? And I'm going to open that for you.
That is a signature snippet of a signature belonging to that account.
Okay, so this would be Mr. William K. Errico's signature?
Objection. Unknown.
Well, it's supposed to be,
Correct.
mind the
Supposed
clerk
to be.
having clarified, it's supposed to be,
Okay.
and that you may be able to lay a foundation for, under their policy and procedure as to the signature if that's critical, but
It's not. Mr. Mwangi, you would presume that associated with this account, somebody would have collected Mr. Errico's signature, and this is what we're seeing?
Yes,
Okay. And then I'm going into the actual account document. It's account 031009689. What are we looking at here, sir?
this would be this This would be a statement, a copy of a statement belonging to William K. Errico trust account with the address of 20 Gulf Crest Court, Henderson, Nevada, and it's a summary of the records or deposits and checks that were processed on the account on 6/8/2007.
And how many pages are in this particular account archive?
670. 670.
Now I want to skip to a particular page within this so you can explain how this record works. I'm going to skip to page 421. Okay, do you see this as a copy of a check on your screen?
Yes, sir.
Okay. And it appears the check is from December 10th of 2009. It is for $4,338.67. Is that correct?
Yes.
Okay. At the bottom of this document, at the bottom of the page, so I'm looking at the very bottom of page 421. There appears to be a web address here, and then a date. Can you explain what that is?
This is a link for where we store the documents, and that is a system link that would have been printed by the system, including a date of when the check was printed.
Okay, so the date that appears on the bottom right corner of the screen, is that the date that whoever pulled this check and provided it in records would have done that?
Yes.
Okay, so this particular check, as a part of a subpoena production to LVMPD pursuant to grand jury subpoena, was pulled on October 14th of 2011?
Correct.
Okay. Now, how many subpoenas did you receive from Las Vegas Metropolitan Police Department pursuant to grand jury subpoena?
Are we talking about the total, or are we talking about the year 2011?
I didn't understand, but I'll restate my question.
I didn't understand either.
I'm speaking about the police.
Well, I imagine they received a ton of grand jury subpoenas.
Oh, on this case.
So, I mean,
Yes. With regard to William K. Errico,
okay.
how many grand jury subpoenas did your bank receive from the police?
In 2011, we received 2.
Okay, and I'm going to show you the second one. So I'm going into the folder. It's NSB records from NSB to LVMPD. And there's another folder. It says disk created on 12/12/2011. And the subpoena. You see that on your screen, Mr. Mwangi?
Yes.
Okay. Is that the second subpoena that you received?
Yes.
Okay. And it was received when?
It was received the 6th of December 2011. We received it, but it was served on the 5th.
Okay. And how did the subpoena differ from the original subpoena?
The original subpoena did not go into details like this one did, and they had also an account listed on it, and it requested additional items as well.
Okay. So there was things that were not requested in the original subpoena that are requested here?
Yes.
Okay. And you said that you received it on December 6th of 2011?
Yes.
And you responded to it, meaning produced the materials responsive to the subpoena when?
December 12th, 2011.
Okay, and I'm going to show you same folder, cover letter and custodian of records, 12/14/2011. Okay, first page is what?
The first page is cover letter identifying the CD dated December 7, 2011. And it was signed by Terry Wilgus.
Okay. The second page, is that a table of contents?
Yes.
And that's also dated December 7th?
Correct, yes.
Okay, and then the third page is what?
It's an affidavit of custodian of records signed by Karen Gainley on December 12, 2011, and notarized by Janet Hayden.
Okay. So I previously sent you these records that constitute State's Exhibit 1. Are these two grand jury subpoenas, do they support the records that were produced on those particular dates?
Yes.
Okay. Now, was there also another entity that was around the same time subpoenaing Nevada State Bank for the records of William K. Errico?
Yes. Around 10/4, on 10/4, we received a subpoena from the State Bar of Nevada requesting records on William Errico, ESQ.
Okay. And within State's Exhibit 1, I'm going into a folder that says NSB records from NSB to Bar to LVMPD. And I'm opening the file State Bar Custodian. I'm sorry, that's not the folder I want. I'm going into bank records May 2007 to Jan 2010. And I'm opening a document called Table of Contents. You see that on your screen, Mr. Mwangi?
Yes, sir.
Okay, you had just testified that the State Bar subpoenaed Nevada State Bank on October 4th of 2011, correct?
Yes.
Okay, and did you produce records responsive to their subpoena?
Yes, we did.
Okay, and the table of contents that I'm displaying on the screen is dated October 19th of 2011?
Yes.
And that represents all of the records that were produced on that particular day responsive to the subpoena and sent to the State Bar of Nevada?
Yes.
Okay, that includes 4 different accounts, including the trust account?
Yes.
Okay. Large time frame, May 2007 to Feb 2010, correct?
Correct.
Okay. And then, seeing how I've sent you this document, or these documents ahead of time, are the records that accompany this table of contents the actual bank records that are responsive to the subpoena?
Yes.
Okay. So if I go into folder account 031009689 and the document account 031009689, are these the records that were produced to the State Bar of Nevada?
Yes.
Okay. In total, how many productions to the State Bar of Nevada were done?
In 2011, 1.
Okay. What about beyond 2011?
I'll have to look at my records. I do not have that answer.
Okay. With regard to what I had sent you previously, was there at least 2 productions to the Nevada State Bar?
Looking. Yes.
Okay. And I'm going into the same folder, NSB records from NSB to Bar to LVMPD. And there is another folder titled Bank Records Jan 2010 to Feb 2012. And in that folder, there's a table of contents. I'm going to open that for you, sir. Okay, February, there's a letter on your screen. Do you see that?
Yes, sir.
All right, what is this letter?
This is a table of contents identifying the records that were released to the State Bar on February 21st, 2012. by Terry Wilgus. Details the accounts and everything that was produced in response to the subpoena.
Okay. And seeing how I've sent you this previously, do these table of contents represent the bank documents that are in the folder?
Correct, yes.
Okay. Were there other productions of bank records to the State Bar of Nevada?
Yes.
Okay. But I have not provided you those records
No.
in preparation for the hearing?
No.
Okay. Now, seeing how there were subpoenas received from the grand jury of the Clark County for LVMPD, as well as subpoenas pursuant to Supreme Court rule from the State Bar of Nevada, were these matters being worked on around the same times?
Yes.
Okay. And can you explain if there was any overlap in production of records from your part?
Yes, there was some overlap on the records between both subpoenas, all three subpoenas and both subpoenas.
Did you do dry runs of reproducing all the materials from scratch on each event?
No.
Can you explain how you produced the materials responsive to the subpoenas to LVMPD and then the State Bar?
We simply copied some of the materials that were already produced previously to save time on those.
Okay, so are you saying to the extent that the subpoenas were similar, you simply photocopied what had been provided to one entity and sent it to the other?
Yes.
Okay. What about custodian of records affidavits? Did you photocopy those as well?
No. We use, okay.
Say that again?
No.
Okay. So some of the marks that appear on one set of records are going to be similar to the other based upon they were photocopied?
Yes.
Okay. I'll pass the witness.
All right. Terry?
Thank you, Judge.
If you need me to access an exhibit, I'll be happy to do so.
All right, I appreciate that. Good morning, sir.
Good morning, sir.
You indicated earlier that Nevada State Bank took over other banks, correct?
Yes.
And could you tell the court approximately when that was?
I do not have exact dates.
I noticed on one of the documents that my colleague showed you, it was from Silver State Bank. Does that refresh your memory that Nevada State Bank took over Silver State Bank?
Yes.
And were there other banks that Nevada State Bank took over?
I have to look into that. But there probably were.
And would that have been as a result of the financial crisis that hit in 2008 and 2009 that involved banks?
Yes.
Okay. And are you familiar with that crisis?
With what questions?
I missed that. I'm sorry. Would you repeat your answer?
Yes.
Well,
Yes, okay.
Okay.
And when you say you took over other banks, is that because other banks no longer had the liquidity to function?
That's not within my purview.
And in fact, some of those banks had filed bankruptcy, correct?
That's not within my purview.
I'm going to ask you to repeat that answer.
He says that's out of his purview. He says that's out of his purview.
Okay, thank you very much. In reference to the subpoenas that were issued by the grand jury, was it the bank policy to notify Mr. Errico of those requests?
That's not within my purview.
That's how what?
That's not within my purview. I only respond according to what the bank policy advises me to do so.
Well, I'm asking about bank policy. Was it bank policy to notify the holder of an account when a subpoena was issued by a grand jury?
That's not within my purview.
I'll ask the same question in reference to the State Bar of Nevada. When the State Bar of Nevada issued a subpoena to your bank, was it the policy of the bank to disclose or not to disclose that to the person that was on the account that was the subject of the subpoena?
That's not within my purview.
Okay. You've worked for the bank for 20 years,
Yes, sir.
and that is not in your purview.
No.
Okay. If this was a subpoena by someone other than the grand jury or the state bar for an account, would the bank have disclosed that to the holder of the account?
If it's within bank policy.
Right. Are you familiar with that policy?
No.
I noticed that in reference to some of the documents that you were asked by my colleague to review, there were signature cards. You recall that?
Yes.
Okay. Were there signature cards from Nevada State Bank, or were they from a prior bank that had been taken over by Nevada State Bank?
Could be mix of both.
I believe your response was it could have been a mix of both.
That's
Is
what
that
I
accurate?
understood him to say, yes.
Okay. When Nevada State Bank took over from another bank, was it your policy to request a new signature card for Nevada?
That's not with. Sorry.
Go ahead.
That's not within my purview.
Okay. Court's indulgence, Your Honor.
Sure.
I'll get to that. Go into these. I'm going to show you an invoice from Nevada State Bank dated December 7, 2011. And that is in reference to a Clark County grand jury exhibit. And when it comes up on the computer, you'll be able to see the number of images that were produced by the bank. That is going to be my question. Was this the number of images that was produced by the bank?
Yes.
Do you see it? You see the invoice?
Not yet.
All right.
don't see
And that
it.
invoice is dated December 7, 2011?
Yes.
Okay. And it says images 2,353, correct?
Correct.
Now, what account is this for, or is it for multiple accounts?
It's for multiple accounts.
Right? I'm now going to show you a Nevada State Bank invoice dated February 21, 2012. And this was a subpoena from the State Bar of Nevada to Nevada State Bank. And I believe that my colleague showed you a copy of that subpoena. Do you recall?
No, not a copy of the subpoena.
Let me show you the invoice. You see the invoice?
Yes, sir.
That is for 1,526 images, correct?
Correct.
So that would mean that Nevada State Bank produced that amount of images, and it took the bank 20 hours to do that, correct?
Correct.
On the December 7th, 2011 invoice, where 2,353 images were produced, it took 8 hours to do. Correct?
Correct.
Can you explain the difference?
That would have been what Terry Wogas recorded at the time of producing the records.
So the answer is you cannot explain the difference, correct?
Why don't you repeat the question, Mr. Terry?
Pardon me?
Why don't you repeat the question?
Sure. So that would mean you cannot explain the difference. Would that be correct?
Yes.
Because that would have been Terry Wilgus, W-I-L-G-U-S, responsibility, correct?
Correct.
Okay. Now, the next document I'm going to show you is a affidavit of a custodian of records. And it's dated February 24, 2012. You see that one?
I don't see anything. Do you have anything?
Can you see that one?
There we go.
Yes.
Okay. This document is actually signed by you, correct?
Correct.
Okay. At the very top it says Affidavit of Custodian of Records, case William K. Errico, and then there's a case number on it. Case number SG10-0625. Is that a case number that's generated internally by the bank?
No.
What is that case number then?
If I recall correct, that would be the state bar's.
The State Bar?
Yeah.
Was that your response?
Yes.
Okay. So this affidavit was prepared for you in compliance with the subpoena issued to Nevada State Bank by the Nevada State Bar, correct?
Yes.
Okay. Now, Nevada State Bank received a subpoena for account number 1939, and that's not the whole number, but those are the 4 digits that I'm referring to, on or about October 19 of 2011. Do you recall that?
Yes.
Okay. And that was from the State Bar, correct? Correct?
Let me look. I'm looking. That's not that. Whatever you're showing, that shows grand jury.
We'll show you a different one. Okay. I believe it is now on the screen. Do you see that?
Yes.
The State Bar of Nevada. And there are a number of accounts that are listed there, including the one that I questioned you about that ends in 1939, correct?
Correct.
Okay. So may the court assume that the State Bar of Nevada issued a subpoena for information on these 4 accounts, which included the 1939 account, correct?
Correct.
All right. Now I'm going to show you the grand jury subpoena for October 18, 2011. Do you see that before you?
Yes.
And isn't it true that that document from the grand jury does not ask for anything in reference to account number 1939?
It's not listed. Yes, it's not.
Okay. Was there ever a point in time when the grand jury issued a subpoena for account number 1939?
Yes.
And when was that?
The subpoena was dated November 10th, 2011, and served to us on December 5th, and we received it on December 6th, 2011.
Okay, so what was the date that you would have received that? For that account
December,
number, 1939.
December 5,
December 5 of what year?
2011.
Court's indulgence, Your Honor. So basically, you've got the State Bar and the grand jury asking for the same records during the same period of time, roughly October of 11 to December of 11, correct?
Correct.
Court's indulgence.
Sure.
Invoices are in. I'm going to show you one other document. As soon as it comes up, I'll give you the date. This is a affidavit from a custodian of records, and I believe that's your signature on it, correct?
Correct.
And that one is dated September 10, 2013, some 2 years approximately later than the other ones that we've referred to, correct?
Correct.
Okay. What is this custodian of records affidavit in reference to?
I don't have that information, but by the looks of that, it looks like it belongs to another grand jury, another state bar subpoena, but I'm not 100% sure. I have to look.
You're not able to say whether or not this is a grand jury subpoena versus a state bar subpoena. Would that be accurate?
With the number on there, that could be possibly state bar.
This would have been in 2013.
Yes.
Do you have any knowledge of what was subpoenaed at that point in time that would have caused you to do an affidavit of a custodian of records in 2013 to whatever entity had issued the subpoena?
I would have to look at my records. I do not have that information readily available.
Okay, when you say you have to look at your records, that doesn't mean you have it right there and you want time to take a look at it. Is that accurate?
No. Yes.
Okay. Yes, that's accurate?
Yes, that's accurate.
Okay. Judge, we're just looking at other records. Bear with me.
I've got all day scheduled for this, so you do whatever you need to do. I don't feel you need to take all day, but
Well,
you do have all day for this.
I understood, Judge. Nevada State Bank at this point in time, 2011, and let's start with 2011. Did it guarantee funds in the bank?
That's not within my purview.
It's out of your purview. Okay.
Yeah.
So, for example, if I were to ask you whether or not Silver State Bank had that policy, you would not be able to respond to that, correct?
No.
Okay.
Correct. I would not be able to respond to that. Not within my purview.
I'm also going to object. I believe it's outside the scope of this particular hearing.
Oh, we're here, and he's here. I'll give you a little bit of play,
All right,
but at
thank
this
you.
point he's saying it's outside.
I won't have a lot of
his purview,
questions more on this.
so- Okay.
Isn't it true that the federal government insured funds up to $250,000 at roughly the period of time of 2011, but no more than that if the bank went under?
And Your Honor, again, I'm going to object.
Well, let's see if he knows it. If he
That's not within my purview.
okay.
Out of his purview. Can I confer with Mr. Errico for a second?
Did we lose connection?
No, I'm sorry, sir. The defense counsel is conferring with his client. I'm anticipating there'll be a few more questions for you, but I'm also anticipating it shouldn't be too much longer. So if you'll just stay there, and that's something we probably should think about, is getting something to play. And we're in these pauses so that people know they're still connected. So.
Perhaps one more series of questions.
Go ahead.
Back to the affidavit of the custodian of records dated February 24, 2012, which you signed, and we're going to put up that back before you. I want to point out paragraph 4. It indicates you certified that the records attached are a true and correct copy of the original records maintained and created, correct?
Correct.
I thought your testimony was you simply made copies of those documents which had already been produced.
Yes, we maintain those records within our system, within
So you didn't look at the
Nevada State Bank system.
So you wouldn't have looked at the originals, correct?
There would be copies.
Okay. So the affidavit is slightly misleading, correct?
I don't know.
Well, it says that you reviewed the original records. That is not accurate, is it?
It's a true copy of the records.
Okay. We already brought that up. Nothing further, Judge. Pass the witness.
All right. Redirect.
No redirect.
All right. Well then, sir, thank you very much for cooperating with us in terms of making your appearance remotely. We're just getting started with doing these kind of things in evidentiary hearings, so it's a little bit of a new process for us, obviously a new process for counsel. Imagine it's a little bit of a new process for you. So I want to thank you for your cooperation with us this morning, and you are excused.
Thank you, sir, and have a great day and be safe.
You too. Thank you.
May we take 5, Judge?
Sure. Do you state have a problem with taking 5 minutes?
No, Your Honor.
All right, we'll take 5.
Thank you, Judge.
All right, let's go back into session, I guess, and state may call its next witness.
State calls Mr. Colin Haynes.
Okay. Is this going to be a live witness?
Yes.
All All right, sir, you come up to the witness stand.
Got the transcript.
Stay standing for just a second. Our clerk will swear you in.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated and state and spell your first and last name for the record.
Is that okay, sir?
I don't have a problem. Does anyone have a problem if the witness removes his mask to testify?
No, he's significantly far from us, so.
I know. What about my staff? Anybody have concern?
Thank you. My name is Colin Haynes. That's spelled Colinhaynes.
All right, go ahead, counsel.
Could I have opposing counsel turn off share screen? Your documents
I'm so
still up.
sorry, thank you.
Thank you. Mr. Haynes, what do you do for a living?
I work for Metro Police as a senior financial intelligence analyst.
How long have you done so?
A little over 10 years.
And prior to that, what occupation did you hold?
I was an investigator with the Nevada Secretary of State's office, investigating investment fraud, securities, for about 3 years, and about 3 years working with the Attorney General's office as an investigator, doing other consumer-related fraud. And 5 years with Metro prior to that, from about 98 to 2004, working for Metro as an abuse and neglect specialist, investigating elder abuse and elder exploitation and child abuse.
Okay. Did you have occasion to be the financial investigator on an investigation and later criminal case prosecution related to William K. Errico?
Yes, I did.
And in the course of your financial investigation, did you obtain grand jury subpoenas for financial accounts related to Mr. Errico?
Yes.
I'm going to share my screen. Okay. Okay, in States Exhibit 1, I'm going into a folder that's titled NSB Records from NSB to LVMPD. Are you familiar with that folder, sir?
I am.
Okay, and there are two folders within that. I'm going to the first one. It says disk created on 10/20/2011.
So I can't actually see.
I know, I'm just making
Okay.
a record. Once I launch a PDF, you will be able to see.
Yes.
And I'm launching a document titled Subpoena.
Okay.
And I'm zooming out so you can see more of the document. Are you familiar with this document?
Yes, I am.
And what is it?
It is a subpoena that myself and Detective Downing issued to Nevada State Bank to obtain bank records related to Mr. Errico's accounts.
And on what date was this authorized by the grand jury?
27th of September 2011.
And on what date was it served on the bank?
The next day, the 28th.
Okay. And with what detective were you working?
Detective James Downing.
And was he working on your squad at the time?
Yes, that's correct.
And did you have a hand in helping him to fashion the contents of this grand jury subpoena?
Yes, I did.
Okay. Around that time, September 27, 2011, did you send any other grand jury subpoenas to any other entities?
Yes, a subpoena was also sent to the Nevada State Bar to obtain records that they may have related to Mr. Errico.
Okay. Did you receive anything in response to the subpoena to the state bar?
No.
Okay. Later, did you subpoena the state bar and receive anything?
Yes, a second subpoena was issued some months later, and the State Bar responded to that subpoena.
Okay. With regard to the subpoena that's still on your screen, the one to the bank that was sent on September 28th of 2011, did you receive records from the bank in response to this subpoena?
Yes, we did.
Okay. And I'm opening a document that's next to that subpoena document. It's called Custodian of Records and Cover Letter, 10/20/2011. Is this a summary of the materials that the bank gave you in response?
Can you scan down the page, please?
Of course.
Yes.
Okay, so there's a cover letter, Custodian of Records affidavit, and invoice for billing, correct?
That's correct.
Okay. And then within the folder, William K. Errico, there's a table of contents which I'm opening. And it's dated October 18th, 2011. Do you see that, sir?
Yes, I do.
Is that a summary of the records that were produced to you?
Yes, it is.
And are those records in folders that are around this particular table of contents?
Yes, it
You
appears
won't
to
be
be.
able to see them because I'm not able to share my desktop, but I'll open up the records.
I can see there's one next to it that says account starting with 0310.
Okay. So if we go to the folder that says account 031009689, is that the trust account of Mr. Errico?
Yes.
All right, I'm going to open that document. And I'm going to go to page 1. Familiar with this, Mr. Haynes?
Yes, I am.
And what is it?
This was the bank statements and the deposits and debits from this account for the attorney trust account belonging to William Errico.
Okay.
The documents covered from early June of 2007 through the date of the issue of the subpoena, which is the end of September of 2011.
How many times did you send subpoenas to Nevada State Bank for records?
Twice.
And did you receive records responsive to those subpoenas on those 2 occasions?
Yes.
Okay. What was the point of sending another subpoena after you've done the first?
There were 2 reasons, actually. I noted that the original subpoena, the bank provided 3 bank accounts, records for 3 bank accounts. In reviewing those, I could see that there were at least 1 additional bank account that the bank had not provided. So I contacted the bank and verified that they'd actually missed an account. So the second subpoena, along with the first, was asking them to produce the records related to the missed account. It turned out there was also a 5th account that was not opened until January 2011 that they hadn't sent. So the subpoena obtained those 2 accounts, plus I asked the bank to provide the additional month and a half, 2 months of records, the October and November period for the 3 accounts we already had. So the second subpoena provided us with a couple of months on the 3 original accounts, plus the entire time frame for the 1 missing account, plus the time frame of January 2011 to November 2011 for the new account. 5 accounts altogether.
Now, with regard to our earlier discussion about you, grand jury subpoena, the Nevada State Bar, did you eventually receive records from them?
Yes.
Did those records include bank records?
Yes.
Okay, so in the course of your analysis of what they provided to you, did it appear that the State Bar of Nevada had subpoenaed the bank for financial records?
Yes, they had.
With relation to William K. Errico?
Yes.
And did they receive records that was responsive to their subpoenas?
Yes, the 2 subpoenas that we obtained from the State Bar in response to our subpoena to the State Bar, their 2 subpoenas accompanied bank records, 2 sets of bank records that was sent to the State Bar by Nevada State Bank.
Were the records substantially similar, or were there any differences?
Between the ones we got from the bank and the ones they got from the bank?
Yes.
They covered the same accounts, but I guess the structure of the production was substantially different.
And just to get on the same page,
Judge, I'm going to object to that last answer, and I had to think about it for a minute. Even he indicated, I guess, so it's highly speculative. We had the first witness that testified in reference to the subpoenas. So, objection speculative.
Well, I'm thinking of the answer he gave. He essentially was a comparison of the records indicating there was substantial overlap, and the structure of how they were presented was different. I don't see anything speculative about that.
You should recall that part of the exhibits that we gave to the that we asked the prior witness about showed the differentiation of the amounts of documents that were sent.
Well, it's not speculative. He had the documents in his hands and he made a statement as to what he observed. You can certainly cross-examine him on that. I'll overrule the objection.
Very well.
Mr. Haynes, I'm going to go into a folder that's titled NSB Records. This is within States Exhibit 1, NSB Records from NSB to BAR to LBMPD. And the document State Bar Custodian of Records. So what are we looking at here?
That is the subpoena that we issued to the Nevada State Bar to obtain their records pertaining to Mr. Errico.
Okay, and this was issued on May 3rd, 2012?
It is dated April 5th, 2012.
Okay.
And served April 9th, 2012.
And then on the, so that was, the subpoena encompasses the first page. The second page is what?
That is a standard formatted custodian of records form that we attach to every subpoena in case the respondent doesn't have their own custodian of records format.
So it's a blank.
It's a blank. It's if they need to use one if they don't have one.
Page 3, what is that document?
That's a typed custodian of records form from Tiffany Bradley, investigator with the State Bar, attesting to the records. That was provided with the records.
Okay, and there's a seal and it's signed at the end?
Yes, that's correct.
Okay. So the first grand jury subpoena you served on the State Bar produced no records. This would be the second?
This is the second one, yes.
Is this the final one? Are there any additional grand jury subpoenas?
There were no additional grand jury subpoenas to the State Bar.
Okay. And the bank records received in relation to your subpoena of them, I'm going into a folder titled Bank Records from Jan 2010 to Feb 20, I'm sorry. Sure. Jan 2010 to Feb 2012. And an account 031009689. I'm sorry, let me just go to the table of contents. Okay. Is this documentation that you received from the bar pursuant to your subpoena to the bar?
Yes, that was included in the documents the bar sent to us.
Okay, and it states basically what records they received, just in a similar fashion to what the bank sent you, correct?
Yes, that's correct.
Okay. Was it more expansive than what you received from the bank?
Yes, our final subpoena to the bank obtained records up to November of 2011. The last bank records we had directly from the bank ended in November of 2011 because we didn't issue any more subpoenas to the bank. The State Bar's subpoena covered the period up to February of 2012. So the records provided by the State Bar would have included December, January, and February of 2012, December 2011, January and February of 2012. So it was more expensive.
Okay. Are you familiar with some of the similarities and differences between what the bank produced to you and what the bank produced to the bar?
I am.
Okay. I would like to refer your attention to, go back to the root menu. I'm going into NSB records from NSB to bar to LVMPD.
Okay.
So these are the records the bank would have sent to the bar. Bank records from May 2007 to Jan 2010. Count 03109689. And within this, I'm going to page 210. You see that on your screen, Mr. Haynes?
Yes, I do.
And what is it?
It is a transaction that occurred on that trust account for, difficult to read from there, 15,000. Oh, Yeah, $15,250.
Okay, it's a deposit slip or some kind of transactional slip?
Looks like a withdrawal.
Now, at the bottom of this particular page, page 210, it looks like a web address and a date, correct?
Yes, that's correct.
Okay. And now I'm going to go to another set of records. I'm going to leave that up so we can switch between them. So I'm going to go into NSB records from NSB to LVMPD. Disk created on 10/20/2011. William K. Errico. Account 031009689. I'm opening that document, and I'm going to page 184. What do you see on your screen, Mr. Haynes?
That's the same transaction. The withdrawal slip for the same $15,250. Excuse me.
Okay, these are the records you received from the State Bar of Nevada?
Yes, that's correct.
And at the bottom of that same page, correct?
I'm sorry. Is this the one that came straight to us from the bank?
Yes.
This is what came from Nevada State Bank.
Okay, yes, I misspoke. My apologies.
The first one was from the State Bar.
All right, so on this one, at the bottom of the page, in the bottom right-hand corner, we have a web address and the date 10/13/20.
That's correct.
11, sorry, 10/13/2011.
2011.
If we go back to the one that went to the bar, it's exactly the same, correct?
That's correct.
Okay, so you received the same record in this particular case with the same bottom footer, correct?
That's correct.
All right. Are there records that you received that the bar received? I'm sorry. Are there records that you received from the bank and that the bar received from the bank that have different bottom dated footers?
Yes.
Okay. So I'm going to, let's see. So I'm in the bar's records right now. I'm going to go to page 435. Okay. So we are going to NSB records from NSB to bar. Bank records January 2010 to February 2012. Account 031009689. Okay. Going to page 5.
For what page?
5. And this is the trust account for William J. Errico?
That's correct.
And now I will be opening. So that was records to the bar, correct?
That's correct.
Now I'm going to go NSB records from NSB to LVMPD. So these are records from the bank to the police.
Yes.
Going to disk created on 10/20/2011. William K. Errico. Account number 031009689. And page 421. Okay. So looking at the bar, again, I'm going to the one that bank records produced from Nevada State Bank to the State Bar of Nevada. What do we see on our screen?
A check drawn on the client trust account belonging to Mr. Errico, payable to ACS Recovery Services.
Okay, in the amount of $4,338.67.
That's correct.
From December 10th of 2009.
That's correct.
And at the bottom of this page, there's a document production date of what?
February 21st, 2012.
Okay, and that follows a web address.
Yes, that's correct.
Okay, if we go to the record that was produced from the bank to the police directly, Is this the same check we were just looking at?
Check 1692, yes, that's correct.
Okay. At the bottom of the page, what date do we have?
October 14th, 2011.
Okay, so the records to the bar were February 21st, 2012. The records to the police were October 14th, 2011.
Yes.
Okay,
That's
so
the
there are
standard.
differences in what was produced to the bar and what was produced to LVMPD, even when we're looking at the same exact record.
Yes, in terms of the where these stamps exist, some of them are similar. In some cases, they are different. The dates are different for the same item.
Now, with regard to the bank records you subpoenaed from the State Bar of Nevada, did you ever send the State Bar 1,000 pages or 1,100 pages of financial documents?
No.
Did you send 4 pages to the State Bar?
Yes.
Can you explain the circumstances under which you sent 4 pages to the State Bar?
Yes, on I think it was April 5th or April 4th, 2012, I sent an email to Tiffany Bradley. The email said, I think the subject line said Bosserman final settlement check or something similar. It had a 4-page attachment, a PDF document attached to it, which consisted of the bank statement, 2 pages of bank statement, a deposit slip, and a copy of a deposited check into Mr. Errico's business checking account, not his trust account. The check was a $295,000 check from the county court, payable to James Bosserman. During the course of this investigation, I learned that the State Bar's figures for settlement money in this case was exactly $295,000 different from mine. Their figures were less, and it occurred to me that this particular settlement check that Mr. Errico had received in this case, the circumstances were quite different from the other 5 settlement checks. This one came about a year later. He didn't deposit it into his trust account. He put it into his checking account, his business checking account. And it wasn't from a insurance company. It was from the court. It appeared to me that this could explain the difference between the figures I had for the money received in this case, which was a little over $1 million, where the State Bar's figures were somewhat over $700,000, $295,000 difference. I didn't know if that was because the State Bar had not seen this check, if they had not realized this was part of the settlement or part of the case, or if they had seen it and they had some information that indicated that that it wasn't applicable to this investigation, that maybe there was some reasonable explanation for why it was placed where it was placed and what happened to it. So I had copied that check to Tiffany Bradley. One point was to, if they were missing it, that they would then have a complete, they would have the record. If they weren't missing it, and in fact they had dismissed it, I might find out there was some reason why I shouldn't include it as well.
Okay, so summarizing, it's fair to say that there was a discrepancy between your accounting and the State Bar's accounting as far as monies that should have been received on behalf of Wilfred Bosserman?
Yes, that's correct.
And that specific discrepancy was $295,000?
Yes, that's correct.
You had determined from your examination of the records that you received from Nevada State Bank that there was a check for $295,000 received into not Mr. Errico's trust account, but into his business checking account?
That's correct.
And that check in some way related to Wilfred Bosserman?
Yes, it was a settlement check from what Safeco Insurance Company had paid $295,000 as part of their settlement of this case. And this deposit, even though it wasn't from the insurance company, was that money.
With relation to it not coming from Safeco directly, it came from the 8th Judicial District Court?
That's correct.
Clerk of the court?
Yes.
Okay. Was that from a settlement conference?
Yes.
And when you made inquiry to the State Bar, you explained it was to discuss the discrepancy in the accounting?
I don't recall actually talking to anyone at the State Bar. I believe I had a discussion with James. I may have done, but this is 8 years ago. I don't recall a conversation. I do recall talking to Detective Downing. Obviously, this was his case and I was assisting him. So I don't know how I obtained the information that there was a $295,000 difference in the figures. I just recall that I knew there was, and that this check appeared to explain it.
In reaching out to the state bar about the 295, discussion or not, if the state bar had a good reason why it wasn't attributed to theft, would that have bore any relevance on whether to charge him with stealing that money or not?
Oh, absolutely. If there was an explanation for that suggested that particular payment was not misappropriated or stolen, then it would not have been included in any of our analysis.
Okay. Putting on your screen from State's Exhibit 1, Bosserman Final Settlement Check, HTM. Is this the email that you sent to Tiffany Bradley, who's an employee of the State Bar, on April 5th of 2012?
Yes, that appears to be it.
And do you know what Miss Bradley's position with the State Bar is?
I believe she's an investigator, or she was. I don't know if she still is.
So, a non-attorney investigator?
Yes, I believe so, yes.
All right. This particular exhibit, it talks about an attachment. And can you read the name of that attachment to the record?
DOC, you referring to that line?
Yes.
DOC 0407 442012 0405 093652.pdf.
Okay. And there actually isn't any discussion or attributed comment on what the attachment is in your email, in the body.
No, that's correct. I just attached the 4-page document and emailed it to her.
But there is a subject line, and that says Bosserman Final Settlement Check.
That's correct.
Okay. So to get to this attachment, I'm going to have to launch another exhibit. That is within State's Exhibit 1, titled DOC 0407442001 20405093652. Okay, I have a 4-page PDF on your screen. Do you see that, Mr. Haynes?
Yes, I do.
Is this the attachment that you attached to the April 5th, 2012 email?
Can you scan down, please?
Yes.
Yes, that appears to be it.
Okay, so there are 4 pages in this attachment?
That's correct.
What are the first 2 pages?
The bank statement for Mr. Errico's business account, business checking account for the October through November 2010 period.
Okay.
It's just page 1, and I believe, is that page 2 or 3? You'd have to go down to the second page, please.
What was the relevance of sending page 1 and 2?
It's actually page 1 and 3. That's the page that reflected the deposit. The month, and then the title of the account, the month, and then the individual deposit. You can see there, $295,000 deposit on 11/16.
Okay. And then pages 3 and 4 are what?
Page 3 is the copy of the check that came from the court, payable to James Bosserman for $295,000. And page 4 is the deposit slip for depositing that check into the account.
Okay. And both of these pages of this exhibit have these date footers on the bottom, correct?
Yeah, the 12/6/2011.
Okay. Now, in your analysis of the records, well, before I talk about analysis, where did you get these documents to be able to email them to the bar?
They would have come from Nevada State Bank in response to our grand jury subpoena to the bank.
Okay, and I will pull that up. Going into the folder, NSB records from NSB to LVNPD. Disc created on 12/12/2011. William K. Errico, 2. Count 035011939. Okay, so this is not the trust account of William Errico?
No, this is the checking account, business checking account.
There's 2,114 pages in this particular PDF?
Yes, that's correct.
Okay, I'm going to go to page 1621. Okay, what are we looking at?
That's the same account for the month of October, from October 29th, 2010 to the end of November 2010.
Okay, so is this the document from which you got pages 1 and 3 of that bank statement?
That's correct.
Okay, and we see the $295,000 deposit on this page 1621.
Yes, that's correct.
Page 2 is actually just a filler. It's kind of ledger page.
That's correct.
Then page 3 is the other page that you sent to the bar.
Yes.
And then if we skip down, there are copies of checks that are associated with that bank statement.
That's correct.
Okay, and we also see the deposit slip for that $295,000.
Mm-hmm. Yes, I see that.
And here it is. So this is a page that you sent to the bar.
Yes, that's correct.
And in this particular PDF, it's page 1631.
Yes.
And page 1632 is the actual check.
That's correct.
And it has that 12/6/2011 date on the bottom.
Yes.
Okay. So this is what you received from Nevada State Bank.
That's correct.
And this is what you provided to the bar.
That's correct.
Okay. Did the bar already have this check and this statement?
I wasn't aware of that at the time, but yes, from reviewing the records, that was subsequently sent to us in response to our subpoena to the bar. They already had this check in those bank records that they had obtained directly from the bank.
Okay. And I'll open that up. So I'm going to records from NSB from NSB to bar to LVMPD. I'm sorry. Bank records from Jan 2012 to Feb 2012. And 2010 to Feb 2012.
Mm-hmm.
Account 035011939. And I'm going to page 652. So this is a 1,223 page archive. I'm going to page 652. Is this the same bank statement we've been looking at?
Yes.
I'll zoom out so you can see more of it.
Thank you. Yeah.
Okay, do we see the $295,000 deposit?
Yes, on 11/16.
We see the deposit slip for the $295,000
Mm-hmm. Yes.
on page 656. On page 662, do we see the very same checking deposit slip?
Yes, that's correct.
And on page 663, do we see the check for $295,000?
Yes, that's correct.
And the date of 12/6/2011?
Yes.
Okay. So the bar already had what you sent them?
Yes, they did.
And I want to change the gears a little bit. I just want to ask you some questions that relate to some things that were said in defendant's motions in this matter. And these are things that were mentioned in their motion for relief from established grand jury secrecy breach. Specifically, I'm relating to page 6. You systematically disseminate grand jury evidence to third parties.
No.
From page 9 of their motion, did you leak the police report to the media in this case?
No.
Did you send either a DMV or booking photo to any entity in this case?
No.
Did you communicate with the Guardianship Court here in Clark County with regard to Wilfred Bosserman?
Yes.
And I'm going to close some of these windows. What was the reason that you communicated with the Guardianship Court?
To notify them of concerns that we had discovered during the course of this investigation with regard to the guardianship case for James Bosserman.
And loading an exhibit in State's Exhibit 1. The document is titled LVMPD Filing and Guardianship Case. You familiar with this? I'm going to zoom in. That's at half size.
Yes.
Okay. Titled Filing of Memorandum from the Las Vegas Metropolitan Police Department. And this is in a G case, which is a guardianship G-09-033521-A.
Yes.
In the matter of the guardianship person of estate of Wilfred Richard James Bosserman, an adult.
Yes.
Okay. And this was filed on April 25th, 2012, correct?
Yes, according to that date, yes.
Okay. This happens to be signed by the compliance officer for the guardianship court?
Yes, lend assistance.
Who does she work for?
The court, the Clark County.
Okay. So she is somewhat of an investigative or auditing arm for the guardianship court?
Yes, I believe she was at the time. I'm not sure if she still is. This was a long time ago.
Then the second page, there's only 2 pages in this particular exhibit, is a LVMPD interoffice memorandum to the guardianship court from Detective James Downing, again dated April 25th, 2012.
That's correct.
And the subject matter is Wilfred Bosserman.
Yes.
Did you, even though this is attributed to Detective James Downing, did you have a hand in compiling information that is included in this memorandum?
Yes, I did.
Okay, so your financial analysis played a part in generating the content?
Yes.
And what is the gist of the letter? I mean, the letter speaks for itself, but give us the gist of it.
The purpose was to explain to the court that they had a ward, Mr. Bosserman, who was a ward of the court with his mother, Angela Smalley, as the guardian, the case filed by Mr. Errico on their behalf, and that settlement funds in this particular, in a personal injury accident that related to this ward, had been received, and at this stage of the investigation appeared to have been mishandled. They were not accounted for. The intent was to notify the court, give them sufficient information that they could do whatever it is the guardianship court would do with regard to that particular ward, since he is a ward of the court.
Okay. Did you attach any actual bank records to this document?
No.
And did you disclose any secret information here, or did you generalize?
We generalized. Most of what's in there came from our interview with Angela Smalley, plus obviously some other records, the review of the guardianship records. I was aware none of this money had been reported to the court. that came from the guardianship court records themselves. So I just generalized just to give the court enough information that they could inquire into this matter if they felt it appropriate.
So you had already looked into the guardianship court's record of Wilfred Bosserman?
Yes.
And did you find any initial accountings?
No, nothing had been filed related to settlement of any claims, filing of claims, receipt of money, no accountings, no budgets, no blocked accounts, nothing.
There was a guardianship instituted for Wilfred Bosserman?
That's correct.
And who was it instituted by?
Angela Smalley, his mother, was the guardian, and it had been filed on her behalf by Mr. Errico.
Okay. Now, given your history in investigating elder exploitation and vulnerable person exploitation, do you have a duty to disclose this information to the court?
Yes, under NRS 200-509, the chapter that deals with elder protection, elder abuse, elder exploitation, it includes that we're mandated reporters, but obviously we're also the police, so we report to ourselves or social services. But we also have an obligation to cooperate with all interested parties, which includes the courts of competent jurisdiction, protective services agencies, that sort of thing.
Okay, I'm going to attempt to load State's Exhibit 1, NRS 200.5091. It's not a PDF, so I'm going to have to change something within the share screen. Text document. Okay, you see that, sir?
I do.
And you're referring to NRS 200.5091?
Yes.
And that relates to cooperation of law enforcement and courts of competent jurisdiction regarding identifying potential abuse, neglect, exploitation, isolation, or an abandonment of older or vulnerable persons?
That's correct.
Does a person under guardianship qualify as a vulnerable person?
Yes. In this case, yes.
Okay, so there's a directive that you were operating under when you were communicating this generalized information to the guardianship court?
Yes.
And from your review of the guardianship record, did it appear they were already aware of such matters?
No, they were not aware of any of the financial matters, the receipt of the money and disbursement of it.
Okay. And do you have any kind of obligation as a mandated reporter?
Yes, we're mandated reporters. I am as a department employee, but that is to report, to the department or to a social service agency. So the mandated reporting was already covered by reporting to ourselves. We were already handling it. But this, requires we are required to cooperate with social service agencies, protective service agencies, and the courts in the protection and in the protection of vulnerable adults and seniors from exploitation and abuse.
Okay. And did you distribute any materials to an attorney by the name of James Christensen?
No.
I'll pass the witness.
All right. Cross-examination.
Yeah?
Yes.
Since we're on that subject matter, you're referring to NRS 200.5091.
You want me to bring it back up, though?
Please. You have that in front of you now?
I do, sir.
Mr. Raman?
Yes, I do.
It does not say that you have the authority to disclose grand jury information, does it?
It doesn't discuss grand jury, no.
Okay. Are you familiar with NRS 172.245 dealing with secrecy of proceedings of grand jury?
Yes.
Okay.
Not in specifics without looking at it, but I know what you're talking about.
If you need to refresh your memory, I have a copy of it.
That's okay. If I need
Okay.
to, I'll ask for it. So.
It does not authorize you to disclose information to the guardianship court.
I don't
correct?
think it mentions a guardianship court at all.
Well,
No.
it doesn't mention any court, does it?
I don't know. I'd have to read it to say
Okay.
that, but I know it doesn't say the guardianship court.
My approach? Or how you
Go
want to
ahead.
do it?
No, that's fine. If you mind if Mr. Terry approaches.
No, it's fine. That's fine.
And what NRS are we showing?
Yeah.
172.245, Your Honor.
I'm not sure that approaching is necessary. You already said there's no mention of a guardianship court there, if that's Mr. Terry's question.
Well, I'll let Mr. Terry have some leeway here. Go ahead.
Take a second for permission. You, 172-245. 245? You can disregard my scratches on it.
Okay. And your question, sir?
Have a chance to look?
Yeah.
Okay. I'll step back then, but if you need to look at it again, please
Okay,
let me
thank
know.
you.
Nothing in this statute, which deals with secrecy of proceedings of a grand jury, authorized you to make that contact with the guardianship court. Is that correct?
That's correct.
And you didn't seek a court order from any court to notify the guardianship court either, correct?
That's correct.
You did it unilaterally, correct?
That's correct.
You indicated almost in the beginning of your testimony that the grand jury subpoena that you issued to the bank was authorized by the grand jury. I believe those were the words that you used, correct?
Yes, the grand jury issues it, yes.
Now, when you use the term authorized by the grand jury, you actually go in front of the grand jury and indicate that you're in need of a subpoena for, in this case, bank records for Mr. Errico?
No.
You, as a matter of fact, simply prepare a subpoena and have somebody in the grand jury, maybe the foreman, sign the subpoena, correct?
There's more to it than that, but yes, we prepare the
Tell me
subpoena.
what the more to it is.
You include an email to the district attorney's office. There's a coordinator who works for the DA who handles grand jury subpoenas. You prepare the subpoena, an email which explains the justification for the subpoena. You attach the subpoena as a Word document and email that to the coordinator, and the next day or within a few days, you are returned a subpoena in a PDF form that is signed by the grand jury.
So that document is forwarded to the district attorney?
That's correct.
It would not have been Mr. Raman in this case, though.
I don't know. The district attorney assigns different. My understanding is there are different district attorneys assigned periodically to receive those requests, review them and approve them, and then direct their staff to comply with them.
So what would have been the first date that you requested authorization by the grand jury to issue any form of a subpoena in the Errico investigation?
That first two subpoenas, the one to the state bar and the one to Nevada State Bank, which I think.
And I believe your testimony was 2/27/11 on the subpoena to the state bar, and 9/28, I think I misspoke, 9/27/11 to the state bar, to the state bank, Nevada State Bank, and 9/28 to the state bar. That be right?
Yes, I think it was the end of September 2000.
One day after the other.
Yes, they may have gone at the same day and been signed differently. I think James Downing emailed them, so I'm not sure.
And when you get the records, as you did in this case,
Mm-hmm.
do you return those to the grand jury, or do you take custody of those records?
We take custody of them. They may be, in some cases, every bank is different, and it was different then as it is now. In some cases, the records are returned to the grand jury, to this building, by the respondent.
But that was not done in this case.
I believe in one set of records, we collected one from the state bar. They notified us they were ready, and we collected them. I don't know the other set of records, whether we collected them or they came here and we collected them from here.
You have copies of the request for authorization?
The email?
Yes.
No.
Where would that be?
Probably purged by now. This was 12 years ago.
That would have been a lost document.
We email it to the DA's office, and then the email stays in the system until it's removed.
Would not the DA have it if there's an open investigation on an individual?
I can't answer for the DA's
Would
record
not
retention
Metro
policy.
still have it if there's an open investigation on an individual?
No.
You would purge that with an ongoing investigation?
Well, it isn't an ongoing investigation now, but it is purged, yes.
Well, it was an ongoing investigation in 2011 when you started to issue the subpoenas, wasn't it?
It was, but I don't know when it was
continued
purged.
until 2012
Yes.
and 13 and 14.
No.
No?
No.
When was Mr. Errico arrested on a criminal complaint?
I have no idea.
He was arrested on a criminal complaint, just to make sure the record is clear, not on a grand jury indictment, correct?
I don't know.
Mr. Raman made mention of the fact that there was some type of a report issued by the media in reference to Mr. Errico's arrest. Are you familiar with that?
No.
Did you participate in that?
No.
Did you provide any information to the media?
No.
Did Detective Downing provide that information?
I don't know. You'd have to ask Detective Downing. Not to my knowledge.
You recall having testified on a prior occasion regarding certain of the subject matter which we're addressing here today also?
I do.
Okay. And at that point in time, you indicated that Detective Downing was the lead detective and that he was in contact with the State Bar, correct?
Yes, I believe he had some
When
contact
was
with the
his
State
first
Bar.
contact with the State Bar?
I don't know. Very early in the investigation, I believe, after interviewing Deanne Clark, I think there was some initial contact with the State Bar regarding the fact that we'd received a complaint.
Would it have been before or after the grand jury subpoena was issued to Nevada State Bank?
Before.
So he was already in contact with the bar.
I can't give you exact dates, but I believe he contacted them.
Was the bar
Pretty
providing him information?
I'm sorry, I don't understand your question.
You don't understand my question?
No.
Was the bar providing him information?
Not that I'm aware of, no.
But yet he was in contact with the bar in reference to Mr. Errico?
Yes.
But you're not familiar with what the contact involved?
No.
correct?
Other than notifying them of our investigation. I know that for certain. Anything else beyond that, I couldn't answer.
Were you aware that the State Bar was doing an investigation at roughly the same time as you were, correct?
I was not at the time, but obviously I became aware of it because we were subpoenaing records from them.
And you became aware of it in 2011 because that's when you issued the subpoena to the State Bar, correct?
Yes, that's correct.
Okay. Now, you mentioned in prior testimony a criminal referral. What is a criminal referral?
Could you give me some context of what my answer
Sure.
was?
You specifically said that the criminal referral was made in August of 2011. What is a criminal referral?
There isn't a criminal referral, other than to the DA's office, referring a case to the DA's office. I'd have to see my answer to know what I was talking about. What can you
Well, I could
expand a bit, sir?
the transcript.
Sure.
I'm going to read you the question
Oh,
as opposed to showing it to you.
certainly.
Court's indulgence?
Sure.
I'll go through all that question.
All right.
You recall having testified that you had sent certain emails to the State Bar.
I recall testifying about the email on April 5th, yes.
Okay. What was that email in reference to?
It was titled Bosselman Final Settlement Check and had a 4-page PDF attached to it, which contained a copy of the check.
And that was the one that you testified to on direct examination?
That's correct, yes.
Okay. And that was a check that you received as a result of the issuance of the subpoena to the from the Clark County Grand Jury to Nevada State Bank?
That's correct.
When you did that, did you request authorization from the court or from the grand jury to provide that to the State Bar?
No.
I know Mr. Raman asked you, is this the same document, the State Bar? And you indicated that, yes, it was. But apparently they hadn't located it because it was important enough for you to give a grand jury exhibit to the State Bar, correct?
Objection calls for speculation.
Well, I mean, you can just ask him what he felt about it.
It was important enough for you to give to the State Bar, correct?
Yes.
Did you participate with Detective Downing in formulating any types of emails or texts that sought information from the State Bar?
Other than the subpoena? Are you referring to the subpoena we sent?
Yes.
Yes, I helped in the preparation of the subpoena for the State Bar's records.
As an example, on April 18, 2012, you recall Detective Downing sending Tiffany Bradley, who was the investigator you made mention of earlier with the State Bar, an email that indicated, "Good morning, sorry to bother you, but I'm trying to track down the date of Smalley's last court appearance that we attended. If you could send me the date and then the case number, that would be great." You participate in that?
No, I'm not familiar with that.
But certainly in April of 2012, the investigation was going, correct?
Yes, that's correct.
Okay. Did you participate in the formulation of the subpoena which the State Bar sent to Mr. Errico on April 26, 2012?
No.
You never became aware of the contents of that subpoena?
I actually didn't know they'd sent him a subpoena. I thought they just requested records from him.
So the answer would be no, you
No.
never became aware of it.
No.
Okay. Would it surprise you that the State Bar issued a subpoena to Mr. Errico directly, requiring him, under the bar rules, to provide certain information regarding Deanna Clark, Linda Talley, Angela Smalley? That refresh your memory in any way?
No, I've no idea what that is. I didn't know this, that the State Bar subpoenaed attorneys. I thought they just had the authority to request.
These were the same individuals you were investigating as to whether or not they were victims, correct?
Clark and Smalley, yes.
Clark, Talley,
No,
Smalley.
Clark and Smalley.
Okay.
Clark, well, actually, Clark and Bosserman, but Smalley is Bosserman's mother.
Assuming that the bar issued this subpoena directly to Mr. Errico, and assuming that it was issued on April 25, 2012, we have a copy of the subpoena if you need to see it.
No, that's okay. I haven't seen it. I don't need to see it.
You have seen it?
No, I haven't seen it. I don't need to see
All right.
it.
This was right in the middle of the investigation, which had started in 2011, correct?
No, it was. I had already completed what I was doing with regard to Clark in January of 2012. So I had, when that was issued in April of 2012, I'd already done with Clark. I was still working on Smalley, so it was during the course of the investigation into the Bosserman Smalley matter.
Did the State Bar continue to provide the Las Vegas Metropolitan Police Department, whether it was Detective Downing or you, with information that they had obtained?
No, they responded to the grand jury subpoena with a set of documents that were responsive, and that was it. That, to my knowledge.
You actually testified in front of the grand jury, correct?
I'll answer. If you have a deposition, if you have my testimony there, yes. I don't recall testifying. This is a very long time ago, but yes.
Do you recall testifying that you had read Mr. Errico's deposition?
No, I don't recall testifying to that.
You're not saying you didn't testify that way, you just don't recall it.
Yeah, I don't recall it.
And just so we're clear, the Las Vegas Metropolitan Police Department doesn't have subpoena power. They have to go through the grand jury, correct?
For this sort of stuff, bank records and stuff? Yes, that's correct. We do have administrative subpoena power for certain things, but not financial records or records from the state bar.
And you have the ability to attempt to get a search warrant too, correct?
Yes, we do, yes.
And that was not done in this case.
No.
Court's indulgence, Your Honor.
No problem. Need water or anything?
No, I'm fine. Thank you, sir.
Your Honor, I would note and object that Ms. Wilder's participation seems to be going well beyond simply technical assistance with documents on a computer at this point.
Well, I will say that I've sort of noticed the same thing, but I don't think that's relevant today. That may be more relevant next Wednesday.
We were looking for example, the grand jury testimony.
All right, all right.
I can only bring so much to court, but we have a lot on the computer. You have a few minutes to confer with Mr. Errico, Judge?
Sure, go ahead. You about ready, Mr. Terry?
Ready, Judge.
All right. Just the witness did express to me that he's got a parking until about 12:30. What are you thinking?
Well, I only have maybe like 7 or 8 questions.
I mean, I'm not trying to limit you at all, but I just want if it's
No,
that's what we think, then let's go ahead and get started then.
All right. I asked you on cross-examination earlier whether or not you were familiar with the fact that the state bar had issued a very comprehensive subpoena to Mr. Errico, a member of the bar at that point in time, asking him for information in reference to certain cases.
Mm-hmm. Yes.
As a result of that subpoena, the state bar received approximately 5 boxes of material. Did you ever review any of that material?
Well, I don't know what the state bar received. We received records. I don't know what the state bar received from Mr. Errico, because I wasn't part of that. We received records from the state bar responsive to our subpoena, but it wasn't anywhere near 5 boxes of records. So I would imagine what we received included some of that, but I couldn't tell you because I don't know what Mr. Errico gave them.
Do you recall authoring a report August 31st of 2011?
Which one, sir?
August 31st, 2011.
What is the report regarding? I did one for the Clark, in this matter I did one for Clark, which I think was completed in January of 2011, and the second one related to the Bosserman, which I think was July.
But my questions are going to be in reference to what you represented in there, in reference to information you had received from the bar.
Okay.
All right?
Okay.
Said, I examined the statement.
What's the date of the report you're talking about here?
August 31st.
Okay.
Of what year?
2011.
2011. I thought the
I'm sorry,
bar
January
subpoena to
11,
Mr. Errico was April of 2012.
It was.
Okay.
But there was still the duty to provide information that had already been provided by Mr. Errico to the bar. Just so we're clear, a lawyer has a duty to.
No, I understand that, but I guess you're asking him about a 2011 report. Are you saying there was a previous request from the bar prior to August 31, 2011 to Mr. Errico?
Yes, because that had been ongoing for a longer period.
Okay.
Now, and I did misstate it. This is a report you did January 11 of 2012.
Yes.
Okay.
Yes.
That refresh your memory?
It does, yes.
Okay. And in there you make reference to, I examined the statement that Errico made in the letter he sent to the state bar dated November 15, 2010.
Yes.
And I'm going to stop there. And again, I just advised the court that the Errico State Bar investigation was an ongoing situation even as early as 2010.
Mm-hmm.
And that's why you make reference to having reviewed the Errico letter sent November 15, 2010, correct?
Yes, all of these documents came from Clark.
Okay. So the information that you obtained from the bar was utilized in reference to your criminal investigation, correct?
Are you referring to this?
Yes.
No, this didn't come from the bar. This came from Clark. I don't know where she got it from, but she provided it to us. Presumably, the bar gave it to her. But all of this came from Clark. I didn't have anything from the state bar prior to their response to our subpoena mid-2012. Whenever they responded to our subpoena, 12 or 11.
Well, your
11?
report continues that it's in response to the grievance that Clark had filed.
Yes, she provided us with copies of all of her records when she filed a complaint with us.
You had not been in contact with the bar as of November of 2010, correct?
I had not.
Had Detective Downing?
No, I'm sorry. The complaint from Clark came in August 11, and I think his first contact with the bar reference this was shortly after that. So 2010, no. Have I got my years right?
Yes.
Right. So 2010, no. No contact by me, and to my knowledge, no contact by anybody in our office with the bar reference this matter. We weren't aware of it until the first complaint from Clark in August 2011.
Did you ever have any contact with an attorney by the name of James Christensen?
Not to my knowledge. I don't know who he is.
You did not interview Mr. Christensen?
No.
When the complaint was filed for the warrant in Justice Court against Mr. Errico, were you the author of the complaint affidavit?
The criminal complaint?
Not the criminal complaint, the affidavit in support of the complaint.
No, I think
affidavit filed in support of the complaint.
I think Detective Downing was the author of that.
Okay. Detective Downing utilized information which had been obtained through the grand jury subpoenas, correct?
Yes.
Okay. And that was before Mr. Errico was indicted, correct?
I don't know the sequence of the indictment and the...
I can ask the court to take judicial notice that the complaint was filed before the indictment.
Okay. Yes, then.
I'd ask the court to do that.
Any objection from the state?
No objection.
All right, I'll take notice of that.
And for purposes of refreshing your memory, the indictment didn't come down for a period of 4, 5, 6 months after the complaint. Does that refresh your memory?
I seem to remember there was a gap. Yes.
Okay.
So, yes, I don't remember how long exactly.
Now, going back to the Downing affidavit in support of the complaint that was issued for the warrant of Mr. Errico in Justice Court.
Okay.
Okay. That document utilized information that had been obtained through the grand jury subpoena, correct?
Yes, I would imagine it did, yes.
Okay. Because there was an analysis of the Nevada State Bar records, correct?
Yes.
Okay. And that analysis had been done by you?
Yes, I compared the state bar records that we received
And
to the bank records.
And you didn't receive authorization to disclose that, or Detective Downey didn't receive authorization to disclose that in that court document, correct?
Yes, I guess. We document an investigation when we file an affidavit, when we file the affidavit for the warrant or the complaint.
You receive information through a grand jury subpoena.
Yes.
That is confidential.
Yes.
Okay? Under
172.
Yeah, thank you, 172.
Mm-hmm.
Then that information appears not in an indictment, not as a result of an indictment, but in a complaint.
Yes.
Okay. So my question is, did you get authorization to disclose information that you have obtained in a grand jury subpoena in support of an affidavit, in support of a complaint, not an indictment?
We do that all the time. I mean, we didn't get we did not get specific authorization in this occasion. We do it all the time.
I practice law, I hear that a lot. It doesn't mean it's being done right. okay?
Well, I
So
mean,
what is the answer to my question?
we did not get specific authorization in this specific case to include the investigation in the affidavit.
When you say the investigation, the material that you received as a result of grand jury subpoenas.
Yes, that was the investigation.
All right. Court's indulgence.
Sure.
We're still looking for that grand jury transcript, Judge. Court's indulgence. Nothing further, Judge.
All right, redirect.
No redirect.
Before the witness leave, could you pull up the letter to the Guardianship Court?
Yes, Your Honor. You need it zoomed in, Your Honor?
Just a little bit more than that. Okay, can you go down just a little bit? All right. You indicated most of this came from Smalley.
That's correct.
Was there any of this that was directly and only attributable to the grand jury, to the bank records that were received through the grand jury?
The only part that was directly attributable to that, if you look in the second to last paragraph, second line, where it says, from the client trust account to personal accounts belonging to Errico. The rest of it is principally from Smalley. He wasn't aware of that.
Yes. Where, say that sentence again?
So
Sorry,
the second to last paragraph, which starts an investigation.
Okay.
If you go to the, is an investigation of the deposition of the remaining $800,000 paid to Errico. After the comma on the second sentence at the very end, there's a receipt by Errico, comma, from the client trust account. A significant amount was transferred upon receipt by Errico from the client trust account to personal accounts.
Okay.
Smalley wasn't aware that had happened. He was aware of everything else and pretty much told us the rest of it. That was something that was in the bank records, that transfer.
Okay. All right. Anything further from the state?
No, Your Honor.
Anything further from defense?
No, Your Honor.
Okay. Thank you very much for your testimony here today. You are excused.
Thank you, sir.
State have any other witnesses?
No, Your Honor.
Perry?
Nothing further, Judge.
All right. Well, let me ask, and each side, we did do argument before. I mean, is there anything from the testimony today that the state wants to further discuss, separate from any questions the court may have?
Yes, Your Honor. Obviously, we didn't have the material that was presented in this evidentiary hearing in the previous motion work. The crux of the defendant's motions, two pending motions today regarding the 239A issue in the grand jury secrecy. The true facts of this case provided by both the Nevada State Bar through their custodian records affidavit, Nevada State Bank through Kevin Mwangi and Colin Haynes from LVMPD shows that we don't have this extensive breach that the defense has been claiming repeatedly through their motions. They make many times over in their motions allegations that 1,000 pages to 1,100 pages were provided by Metro to the state bar. That's factually untrue. And that singular fact makes their entire motion fail. Now, they've colored it with a few other little non-factors to try to make this some kind of comprehensive thing. But the picture is that both the State Bar of Nevada and LVMPD had subpoenaed Nevada State Bank for these bank records and had received them concurrently to each other. The testimony from the bank was that because the productions were so similar, they simply photocopied what they had already done so they didn't have to rework. And that's why the date stamps on the bottom of the pages, which was supposedly the smoking gun the defense highlighted, is a non-factor. There's a completely legitimate and reasonable explanation for that. And it's because it was copied to save everybody time and expense. It was provided concurrently to the LVMPD and the bar. The only thing that occurred was Mr. Colin Haynes at one point, as Your Honor saw in the email on April 5th of 2012, emailed the State Bar 4 pages 2 pages of his bank statement, and 2 pages showing a deposit slip and the actual check from the Judicial District Court for $295,000. The State Bar they already had all those records. They had them as early as February of 2012, if not October of 2011. So we're talking about April 5th of 2012. You can't violate secrecy when you're talking and sharing with the party something they already have. It's not a secret. They have it. So the entire motion work on the part of the defense is based upon a fallacy that has fallen today. With regard to any other red herrings that they've tried to raise, there's just nothing to them. With regard to the disclosure to the Guardianship Court, there is statutory authority that investigative agencies who come upon evidence of exploitation of a vulnerable person, which is what occurred in the case of Mr. Errico stealing money from this vulnerable person, has to be dictated to the court. Now, is it red letter, grand jury investigation from a police officer? No. But it is broad enough that anybody who comes in possession of these type of matters should work with the courts. And from personal experience, because I have been working on exploitation for 8 or 9 years and was part of the guardianship reforms with Justice Hardesty, problems like this where the court was oblivious to stealing, especially stealing by a prominent party like the ward's attorney, is why that entire court needed serious reform. Linda Sisson, who's the court compliance officer, as Your Honor saw there, had no idea. As the testimony showed, there was no initial accounting. There was simply a filing of a guardianship by Errico so he could institute a personal injury lawsuit on behalf of Mr. Bosserman, put the mother in charge as the guardian, but then because the mother is not a very bright person, and as they've previously argued back on the hearing Wednesday that they wanted criminal information about her, she's also not a very forthright person. She was duped into not knowing what was happening with the money and constantly churning, oh, he's doing an excellent job, please pay him all this extra money that he is completely not entitled to through the fee agreement that was signed. So all of this stealing takes place, $400,000 plus of money that Errico did not earn, was not entitled to, was never accounted for in the guardianship. These lawsuits were never floated to the guardianship court. Everybody knows if you have a person who's under guardianship and there's lawsuits being settled on their behalf, you have to float that to the guardianship commissioner so it can be approved. There needs to be court approval here. None of that occurred. So it was imperative that the guardianship court become apprised of these issues. The other thing that the defense tries to bring up, which is a complete non-factor, they're trying to build a layer of criminal procedure into our laws that don't exist, is when the police use their only investigative tool to get bank records or other materials through grand jury subpoena, that they somehow need permission from some entity to use the findings of their grand jury investigation in declaring in an affidavit for warrant to a judge that this is the probable cause for the charges and this person needs to be arrested. And all of those affidavits for warrants are filed under seal and are sealed until the person is arrested and brought to court, which is what occurred here in 2014 with Mr. Errico. Declaration for warrant was filled out by James Downing, as Mr. Colin Haynes testified to. He was arrested. He was brought into court under a criminal complaint. And then the media requested the materials because this was somewhat of a person of note. And as per normal records disclosures, they either asked LVNPD or they asked the district attorney's office, please provide us with the arrest report so we can write a news story about this. Now, Mr. Haynes had no part of that. He had not, under oath, sent any information, any third parties, any booking photos, any reports whatsoever. But they're trying to argue that somehow, anytime the police use grand jury information, they need to then apply to, I don't know who, Linda Bell, the foreperson of the grand jury, before they can actually do their job and arrest somebody or declare in a warrant they would like a warrant to arrest somebody. That doesn't exist. The defense has continually argued all these pseudo loopholes in 239A and 172, but they're inventing law that doesn't exist by trying to say that has to happen. Mr. Colin Haynes' answer that, well, that's just how we always do it, And their complaint that, well, that's something that we hear often, it isn't acceptable, has no basis in a matter of law. Not in case law and not in statute. Everything here is above board. Everything here has reasonable explanations. All laws have been complied with. Any claim prejudice is a non-factor. The statement to the guardianship court was general enough. It was not conclusory. It said we had an open investigation. We presume, we approximate, we think it might be in this neighborhood. We're still investigating. We think you should know about that. That is their duty under the law. And there was no security breach by providing the 4 pages to the party that already had the 4 pages. So it's unfortunate that we've had to spend so much time litigating non-issues, but once again, we are here litigating non-issues. I ask Your Honor to deny the defense motions.
All right, thank you.
We don't consider this to be a non-issue, Judge. And I'll be brief.
One sec, Your Honor, I just had one more thing to add. My apologies, Mr. Chair.
Okay.
The other thing, and it's included on the evidence disc, is Errico sued Nevada State Bank, and I've attached the appellant filing on their behalf. So they sued him in district court here. It was denied, I think, summarily by the judge, and now it's in appeal. And I believe it is quite hypocritical because they acknowledge in the facts section of their appeal that Nevada State Bank did, in fact, provide records to the state bar. So for them to constantly argue in these motions that 1,000 or 1,100 pages were solely obtained by the bar from the police doesn't jive with what they're floating in the appellate court, where they're suing the bank because they're claiming that they didn't provide notice to Mr. Errico when the state bar, through Supreme Court rule, which has confidentiality provisions, received records from the bank and didn't tell Errico. So there's a lot going on here. It's just a constant struggle with Mr. Errico, who won't own up to this, not in the bar, not in civil proceedings, and certainly not in the criminal procedure. And their appeal's there, and it's completely hypocritical.
All right, thank you. Terry?
Al?
Yes.
There's a lot of litigation going on in this case because there's some major issues. Okay, and one of them is the one that's before you now. I mean, Mr. Raman respectfully does a good job of going around what the issue is. The issue is, was NRS 172.245 violated? It's very specific. The disclosure of evidence presented to the grand jury, information obtained by the grand jury, the results of an investigation made by the grand jury, an event occurring or a statement made in the presence of the grand jury, may be made to the district attorney for use in the performance of the district attorney's duties. That's what the provision says. It says, except as otherwise provided in subsection 3, the attorney general, who's not involved in this case, a grand juror, district attorney, and it goes on to say peace officer shall, and the word shall is a mandatory word. It is not a arbitrary word. Not disclose evidence presented to the grand jury. An event occurring or a statement made in the presence of the grand jury, information obtained by the grand jury, or the results of an investigation made by the grand jury. Now the statute goes on and says there's exceptions to that, but you have to apply to a court. In other words, don't make a unilateral decision to take it upon yourself. And no matter how Mr. Raman seems to indicate that this attempt to advise the guardianship court was done out of necessity because of the provision that deals with a duty to report some form of abuse, it doesn't circumvent the criminal statute. The criminal statute says you can't use it. Now, we've demonstrated in this hearing and the prior hearing that occurred. Colin Haynes was one of the best witnesses for us. He advised they were cooperating with the state bar. He's the one that testified today that he's the one that brings it to the attention, not based on state bar information, but based upon grand jury obtained information as to this $295,000 check. You have the letter in evidence. Put it up on the screen. That wasn't directed to you, Judge. It's directed Ms.
I
Errico.
understand.
How I am working with Metro on a case which is entitled Angela Smalley versus, and that's signed by Tiffany Bradley, and it's in 2012. I mean, how clearer can it be? And she talks about Wilford Bosserman. She talks about the guardianship. How clearer can it be that there's an exchange of information? Colin Haynes says it, the bar says it. And what the bar does is they send a vast subpoena, which was a secondary thought based upon what Metro wanted, to Mr. Errico, knowing he's got two choices. Take a Fifth Amendment, which will be utilized against him in a bar proceeding, not cooperate, which will be utilized by the bar in a proceeding against him, or not respond at all, which will also be utilized. So he had no choice but to respond. With great respect to Mr. Haynes, I find it a little incredible that the bar gets 5 boxes worth of material and Metro never bothers to look at that when they were so interested in all of the cases.
Well, he said that he may have gotten some of it.
And
he said they
you're
didn't
right.
get 5 boxes of materials from the state bar. So
And then you have the differentiation on the invoices as to the fact that the grand jury gets 2,500 pages worth of material and the state bar receives a lesser amount. Whereas the testimony was that the bar had asked for more than Metro did at a point in time. So this is not a red herring situation. Yes, I raised the issue of whether or not we can use this, the Metro can use this, in an affidavit in support of a complaint, not an indictment, when the information is obtained through the grand jury. It is not that hard to ask for a judicial sanction to allow this to occur. We have a chief judge. We have many other judges. All you do is file, it's sort of like filing an affidavit in support of a search warrant where you know it's sealed. They file it in a sealed way. We need to disclose that. And respectfully, I think that's the way that the federal system would do it if they had to do it that way. But I think that they would be much more cautious in their approach. Metro plays helter-skelter. And the rule, I haven't heard Mr. Raman say, we didn't violate 172.245. What he said was, we probably violated it, but it's no big thing. When it interferes with the Fourth Amendment or Fifth Amendment or Sixth Amendment right, which obviously Mr. Errico has, then it is a big thing, Judge. And that's why you have a fairly extensive brief in support of our position. With that, we'll submit it to you.
all right.
And Christensen.
Well, the major issue that concerned the court looking at the initial documentation file was whether or not a large amount of bank records had been provided from Metro to the state bar. And that, I think, has been explained today with the testimony of the custodian of record for Nevada State Bank, that the decent amount of the records which were being gathered at the same time by the bank in reference to Mr. Errico's bank accounts were just double copied and provided to the different parties. We have Haynes' testimony that they got their records from Nevada State Bank. They did that. In turn, they got records from the state bar that matched. And then the testimony of the custodian, I think, does explain what looked like potential large number of records that may have been somehow funneled from the state's delivery from the bank to the state bar. In this instance, I don't see evidence that that happened. What we're looking at then at this point are three issues as far as the issue of secrecy. One, the email by Mr. Haynes to the State Bar investigator with the four documents relating to the $95,000 deposit. Two, the reference in the memo to the Guardian that it appeared that some of the money being in settlement of Mr. Boserman's case went into Mr. Errico's personal accounts. And then three, the use of grand jury material in the affidavit in support of the warrant. Focusing on the 4 pages that were sent to the State Bar, and then focusing on Mr. Haynes' testimony today. And the issue of secrecy with the grand jury has always been one of some difficulty and to some degree a little bit hard to parse, because the grand jury does not operate in a vacuum. Somebody obtains some materials through the grand jury that raises questions that need to be answered by either additional subpoenas or by interviews or other investigative acts, has to some degree at least, utilize information engaged in the grand jury or obtained through a subpoena in the grand jury to be able to ask somebody a question or to get additional documentation and to do additional investigation. And the state statute, NRS 172.245, and to a large degree paralleling the federal Rule 6E, does provide that disclosure can be made to the district attorney for use in the performance of the district attorney's duties. Obviously, district attorney has deputy district attorneys, and they have investigators, all acting in an agency relationship to the district attorney. And so the issue often comes down to is the information that is being disclosed that may have been obtained through the grand jury being disclosed or used in the performance of the district attorney's duties. And in this instance, as to the 4 pages that were sent, Mr. Haynes testified that he had determined there was a discrepancy in what he had felt was the figures relating to the Boserman incident between what he came up with and what the State Bar had come up with, and that he he felt that it could be explained through this one deposit, and that he was interested in knowing if the State Bar had a different take upon this particular transaction than what he did. In that context, him showing this one deposit and asking, if this is what's the difference between us and you, I think is something that falls within the parameters of using the material in the performance of the district attorney's duties. Just like it would be if you had an interview with somebody and you obtained bank records and you didn't know what this one record meant. I do think you can ask whoever you're interviewing and show them the record and say, what does this one record mean? In that regard, I think that this is not a violation of grand jury secrecy. I disagree with the state that just simply because the State Bar already had this material that you can't violate grand jury secrecy. That's not the context of the rule. The rule only allows whatever disclosure there may be in the performance of the attorney's duty. And just because it may happen that somebody may already have certain information. I do think if the whole purpose of the Mr. Haynes was to give the bar something that they might not already have had, and it turned out that they had it, that was the whole purpose, I think that that would be a violation of the grand jury secrecy rule. But here, while he did express some, and it did bother me that he did indicate to some degree he provided this so that they would have complete records if they didn't have it, he did say that it seemed like his primary, or at least a reasonable material portion of his purpose, was to determine what was the distinction or discrepancy between his figures and their figures. In reference to the affidavit in support of the warrant, this is an interesting point that Mr. Terry brings up, and that is, does if you're seeking to obtain an affidavit or to put together an affidavit for something outside necessarily the scope of the primary focus of the grand jury to issue an indictment, do you have to get some sort of authorization? On the federal side, generally it was always treated as long as it was done in the context of the grand jury investigation, it was generally always treated as something that was use of grand jury material and performance of that would be the Assistant United States Attorney for the government's duties as opposed to the district attorney's duties here. That I would say it would be no different than it would be with obtaining a search warrant in the context of a grand jury investigation, issuing of an arrest warrant in the context of a grand jury investigation, or the issuing of a preliminary complaint in the context of the grand jury investigation, I think fall within the idea of performance of the district attorney's duties. That, I won't say, Mr. Terry, that that's not an argument. I've seen different districts of federal districts do things differently when it comes to grand jury materials and disclosure of that. But I don't think that here locally, I don't think that that's inconsistent with the practice followed in the federal district here. And if you do look at Westlaw in reference to citations as to the state's grand jury secrecy obligations, there seems to be several cases, or at least 2 or 3 cases, not a lot of cases, but 2 or 3 cases, which do rely upon federal principles. In terms of the memo to the Guardian, that is something that I see the state's argument that there is a separate statutory provision requiring disclosure of information to the court as opposed to something in the rule relating to secrecy. I don't have those statutes in front of me. I'm pretty sure, though, that the grand jury secrecy provision was passed and became the law prior to the change or to the creation of the obligation in the guardianship statute.
It did, Your Honor. Grand jury statutes, I think in 1974, and the other statutes, actually I have it here so I can pull it up.
That's as long as it's later in terms of my analysis at this point, that would modify the obligations under the secrecy provision and allow the disclosure so that's my view in reference to those three incidences. Assuming for purposes of the argument here that each of those or any one of those did constitute a violation of the grand jury's secrecy, then the issue would be, what is an appropriate remedy in this case? And I don't see, in view of what occurred here, anything as to these incidents which I'm looking at, anything that constituted something that significantly prejudiced the defendant or undermined the purpose of the grand jury secrecy. The very limited disclosure of records to the state bar, very general discussion of possible transfer of funds, personal accounts in the letter, a memo to the Guardian Court. And again, the complaint was essentially an extension or directly relevant to the grand jury and its purpose. So I don't feel that dismissal of the case is appropriate, and I don't feel that suppression of evidence of the case is appropriate under these circumstances. So I will deny the motion, defendant's motion. We have a fairly extensive oral record here. I assume, Mr. Terry, for any potential appeal or anything you would like to have a written order.
Please, Your Honor.
All right, I'd ask the state to prepare a written order based upon my oral record here today.
We will, Your Honor.
All right. Anything else then at this point in time?
Not whatever you have, Judge. Thank you.
Set for trial the end of January. I know we were almost started before. I take it there's nothing at this point that, if not would, we can get a jury together that would keep us from being able to go forward?
That'd be great.
I mean, Mr. Terry, anything you see?
No, Judge.
All right. Well, I'm going to keep my fingers crossed then that we can get the jury picked at the end of January. And you said that you thought things were going to be better in 30 days, Mr. Terry. So I'm hopeful that you're right and that this I don't need to be nervous about this date. All right. Well, again, thank you. I know this was sort of a difficult situation working with the Blue Jeans and here and everything. So I know Angie, our court recorder, worked with you guys and set up ahead of time to try to do some dry runs. I appreciate her doing that. I appreciate you guys coming in and doing that to just try to make this run as smoothly as possible.
Have a moment with Mr. Raman.
Before I leave? Yeah, okay.
I thought Colin was going to be out of town. Did you mention that to him?
No, that might have been a previous January. No. I'll check on it. I don't recall that.
Okay, I thought you mentioned that to me.
No, that was for the last setting of this hearing.
Okay, all right.
Yeah, we had to bump this hearing a week because he was moving his son in at UNR.
That's fine. We're fine, Judge.
Okay, all right, very good then. Again, thank you for working with us and cooperating. Have a great weekend to the degree you can.
I appreciate it. It actually wasn't that hard.
Stay safe.
No more difficult than the first time you learn how to deal with a doc cam, I think.
Like I said, as I commented to you before, I think little by little the applications that are out there will improve and pick up, and we may be on the cusp of a brave new world, it seems. But
Yeah.
We'll see.
No, the only complaint I have about it, and I've done a pretty comprehensive trial with digital evidence, is when you get it back to the jury, unless they have a big screen TV, they can't all crowd around a laptop that was supplied by the state.
Well, we did have, in one jury, I did have a big screen TV back there that we were able to connect the computer up to.
Yeah.
I don't know if everybody has that. I think we sort of just found it out in the hallway. And so,
It's good to use for.
yeah, so I mean, but we were able to connect TV up to it and create a monitor that made it bigger for the jurors to see.
Yeah, we got complaints from the jurors about that. Is what it is.
At least the TVs we got in here now are better than the two TVs we had in here only a year ago.
All right, have a great weekend.
All right, you too.
Thank you, Judge.
Thank you.